Hello and welcome to the new episode of Death and Taxes, a weekly podcast by the private client team at Burgess Salmon. My name is Tim Williams and I'm a tax and trust lawyer in the private client team, and together with my tax and trust colleagues Guy Broadfield and Edward Hayes, we'll discuss a range of issues facing clients and professionals alike. In each episode, we'll be joined by specialist lawyers from around the firm to bring you our views on important topics for private clients. Today's podcast, we're joined by Alyssa Haggarty to talk about philanthropy and how private clients can achieve their charitable aims. Alyssa is a solicitor in Burgess Salmon's UK private client team and regularly advises private individuals and trustees on charity law issues and governance, including a range of charitable structures, alongside her wider private client practice. So, Alyssa, thank you for joining us today. What we wanted to do was to talk through how our clients can best fulfil their charitable aims. And there's lots of options, I'm sure, and lots of practical things to trot through. But if we assume that we've got a client who's recently sold their business, say, and they've got lots of spare cash and they want to put some into charity, broadly, what are their options to do that?
Well, there are three main options. You could make a gift to an existing charity or organisation. You could make a donation to a donor-advised fund, or you might decide to set up a charitable entity of your own. And that's where we come in and can advise on the best structure to suit the activities of the charity.
So, I mean, the first option there of giving to an existing charity, I suppose you've got to, first of all, find a charity that your aims are aligned with. And there are obviously lots and lots of charities out there. But I guess once you've given your money to the charity, you have no say in what they actually do with it beyond fulfilling the charity's charitable objectives. Is a donor advised fund more controllable, or how does that work?
It's sort of an in-between. So you're right. If you make a donation to a charity, you have provided funds or assets, but unless you are a trustee of that charity, you won't have any say or control on how it's used or spent unless you've included specific instructions with your donation. With a donor advised fund, you can make recommendations as to which charities the donation will be used for, and also include any specific limitations with that. But if you would like ultimate control over how your donation is used and a say and to be involved, then establishing your own charity will let you be more involved in the process. But along with that comes a time cost of running a charity and all of the compliance and obligations and duties under charity law that come along with it.
So let's assume our client has decided that they want to create their own charity. There are presumably lots of different structures they can use. Charity is an objective, not a particular vehicle. So what can our client do who's got their cash? What can they put their money into?
You're right, Tim. Charities come in all different sizes. So charitable status is separate from legal status if you sort of look under the hood. And the first thing to do is to take advice on what type of structure would be best. And the ideal structure really depends on what the charity is being set up to achieve and how. So one of the key points to consider is liability. If you go with a charitable trust option, the trustees are personally liable for the decisions of the charity, and they remain so after retirement unless they're released. And so this can be sensible where the charity is a grant-making charity, which is quite popular. But if the charity is going to hold substantial funds or have employees or own and deal with property, then having a limited liability structure is probably better. And the main limited liability structures that we set up are charitable incorporated organizations, or CIOs, and charitable companies.
Quite an interesting point actually there, that I've talked in my example about purely cash going in, but of course charities can actually do other things as well, can't they? So that liability point is really key.
That's right. So you can transfer cash, shares, variety of different assets.
So those structures will help with the sort of administrative side of the charity, but I suppose it's probably worth bearing in mind that the client's charitable aims are it might be quite broad, and they might want to do a mixture of different sorts of charitable giving, be it some to an existing charity, maybe some to a DAF, somewhere between their own charity and an already established charity. So I suppose clients may want to use more than one because they go along.
Exactly. And sometimes it's not a choice of one or the other. You might decide to set up your own charity, but also make donations to existing charities, or also make donations to a donor advised fund. So it's not one choice rather than the others. You can use them together as well.
I mean, I've seen it in the context of where a family or an individual is at the start of their philanthropic journey. They have used a donor advised fund because it gives them a slightly more flexibility, but the setup costs or ongoing costs for that are relatively small. And then once they've got a better idea of who they want to benefit and how they want to benefit, then they can take the next step to create and then fund their own charitable vehicle. And that works quite well as a staged process to help those individuals decide what they want to do and how they want to do it.
That's a great example, and quite popular in families where sort of the younger generation is starting to get involved and looking for ways to get involved and familiar with the decision making and the liabilities that go along with it.
So in terms of those practical steps then, Alyssa, if the client has made the decision to set up their own structure, what are the sort of first things they need to think about in getting started?
So once they've taken advice on the type of structure, the next step would be to prepare the governing document. So in the case of a charitable trust, that would be a trust deed for a charitable incorporated organization. That's a constitution, which is based on a model prepared by the Charity Commission. And for a charitable company, that would be articles of association that then need to be registered with Companies House. And those documents will be the rule book for the charity, and we can advise on the specific clauses that need to be included, as well as the most important clause, which is the objects clause that sets out what the charity is set up to do and who it is to support. And in order to be registered with the Commission, it has to be established for exclusively charitable purposes and satisfy the public benefit test. So that can require some thought.
And so I think at this stage it would probably be helpful for listeners if we just explain what the Charity Commission is, what's its role and function, and how it can affect private clients.
So the Charity Commission is responsible for regulating charities in England and Wales, and they will get involved in the process early on. If you are registering a charity, the application goes to the Charity Commission. A caseworker will review it. They might raise queries or ask for changes to the objects to ensure that it is exclusively charitable. And once a charity is registered, you might see the Commission getting involved if the trustees would like to make some changes that they don't have the powers to do under their governing document. So one common example is if the trustees of the charity would like to change the objects in some way. If they don't have the power to do that themselves, then the Commission would need to consent to a change, and also to do with winding up of the charity. So once you make a donation to a charity, the assets of the charity must be applied for charitable purposes. You couldn't then decide to wind the charity up and go on a fantastic holiday. You would have to apply those funds either to another charity that had similar objects. And most charities will have a clause to that extent. And if they don't, the trustees would need to go to the Commission to ask for consent to merge or transfer assets to another similar charity.
So where you have a charity that's run in the quotes correct way, you can expect quite a lot of dialogue between the charity and the Charity Commission, both set up, but there's an ongoing compliance reporting element there that everyone involved with the charity is going to have to comply with.
That's right. And sort of the ongoing compliance obligations really depend on the type of entity that you choose. That's where we come in, because it may be that if the trustees are time poor and want to make an impact, one entity may be preferable to the other because it has less reporting obligations. So one example is that a CIO is regulated by the Charity Commission alone, whereas a charitable company is regulated by both the Charity Commission and Companies House. So in that case, annual reports, returns, those sorts of documents would need to be provided to both regulators, which is sort of a dual administration burden. It's also quite key that you have your governing document set up correctly at the beginning, because if you provide for flexibility for the future, you won't need to go to the Charity Commission as often to ask their consent to make changes, which can mean that you're much more efficient in running your charity. You've set yourself up well for the future because you've provided some wiggle room if your focus changes slightly.
And also, as to your final point that you made previously, once you've given the money away to the charitable vehicle, that is it. It is to be used for charitable purposes. So there's before you get started, you need to identify how much you can afford to give away, and make sure you're happy with that, because getting it back to fund your next holiday home or other family expenses is not going to be possible.
So once the charity's set up, it is going to have to pursue its charitable objects and make decisions within that framework. Presumably that's done through a group of individuals in each case. I mean, is there a difference between how those individuals operate as between the different structures you've described?
There is. So in the case of a charitable trust, the trustees make decisions unanimously. The decision making is slightly different for a CIO or a CLG. With a CIO, there are two models. One is similar to a charitable trust, where the trustees are responsible for running the charity. And so they are the members and directors of the CIO. So they're responsible for making day-to-day decisions, and also decisions of more significance, like when to wind up the CIO. And it's the same for a charitable company, where you have members that are similar to shareholders, even though in most cases the company will be limited by guarantee, so there aren't shares, but you have that layer of oversight and a check and balance, where the people who are the members are different than the directors. And in some cases, you can have informal membership as well. If you are benefiting a certain community, you might invite people from that community to come to meetings and provide their views. So there's quite a few different arrangements, and it really depends on the activities of the charity and who it's set up to benefit. So there's quite a bit of flexibility there.
So I suppose the involvement of these stakeholders who are maybe potential beneficiaries of the charity can be quite valuable in ensuring the charity is doing the right thing for that community or for those people. But I suppose in that instance, the ultimate control still rests with the board, but maybe better informed by information from those stakeholders.
That's right. The decision-making powers would stay with the directors or trustees for most decisions, and then the governing document would set out where input is allowed from other people, and it really just depends on a case-by-case basis. But the simplest model would be a charitable trust, where the trustees make decisions together, and then it can be more complex than that if needed.
So the makeup of that board of directors, this is presumably quite flexible. Would you typically just have family members, or would professionals get involved, or charity specialists of some sort?
It's a combination. So with charitable trusts, sometimes the trustees will all be family members. We tend to suggest having one or two independent trustees. The Charity Commission recommends that as best practice, because it shows that there's just some external sort of viewpoints. And in relation to CIOs and CLGs, which are companies limited by guarantee, you can have a mix again. So you might have sort of professionals, directors, charity advisors, family members, specialists in the area that the charity is hoping to operate. The main thing is to have a variety of different backgrounds and viewpoints.
So it wouldn't be an episode of Death and Taxes if we didn't talk about tax at some point. So, Alyssa, there are presumably tax advantages for the charity, but there are also advantages for the donors to charities as well. Could you talk a little bit about that, please?
Of course. So, charities are generally not subject to income tax, capital gains tax, inheritance tax, or corporation tax if it's a company. And donations by individuals can also benefit from tax relief, which is gift aid, provided they've paid sufficient tax in the UK. So that effectively increases the value of the donation for the charity. And then if the donor is a higher or additional rate taxpayer, they can receive tax relief on top of that. So in addition to the benefits to the charity, advice can be taken before the donation is made to optimize the donor's position. And sometimes we'll see there's quite a difference if the donor gifts cash versus shares or another asset, whether they sell them first and gift the money, that can change the position quite a bit.
So alongside thinking carefully about your structure, you need to take advice on whether there are advantages to be had in for both you and the charity, of course, in putting different assets into the entity.
So Alyssa, coming back to the aim of today's pod, when it comes to private clients, what are the takeaway points for them as to how they achieve their philanthropic aims?
And so in conclusion, the main points to consider are: first, what do you want the charity to achieve? Second, what is the ideal structure to achieve those aims? Third, how will the charity be funded? Fourth, how will the decisions be made and by whom? And together, all of these factors will help you to create an entity that will have the impact that you're looking to create.
Thanks again for listening to Death and Taxes, a private client podcast from Burgess Salmon. You can find out more about Burgess Salmon and our team at burgess-salmon.com or on our LinkedIn page. On next week's episode, we will be discussing how partnerships work and where they can go wrong. So don't forget to subscribe to listen to all episodes from season 1 and 2.